I've been asked to kick off, and I'm going to do a little self-introduction if I could, just so that you know where I'm coming from, and then I'm going to tell you what I'd like you to take away from my comments as the other speakers get up here. So my name is Harriet Pearson. I am currently and have been IBM's Chief Privacy Officer for 12 years, and have been working at the intersection of law, business, technology, and policy for more than 20 years. And IBM is a global company. I've been there a long time. IBM is a global company doing business in over 150 countries. We have over 450,000 employees. We have data collected from thousands of clients in the business space. We do cross-border management. We have cross-border teams and a very global workforce. And at the same time, we're manufacturing and making some of the technologies that are doing, have you heard about the term big data? You know what big data is? Big data. We are looking at security, at computer security. So we have had an involvement in a lot of different areas. And I've been working in that intersection between what we all do as lawyers and what we do, practically speaking, to say, well, what do we do with this data? How do we protect it? How do we respect privacy? I'm also in the middle of a transition. So I'm kind of an in-betweener. I announced last week, actually, that I'm leaving IBM and joining private practice or law firm practice at the law firm Hogan Lovells. So my future colleague is coming up here and joining me and talking about this area. And one reason that I'm very excited by that is that I do think this area of the law is going to be extraordinarily dynamic. And I agree with you, Dean, and all of you, that it's going to be a very interesting field to be working in, because I think a lot of this is going to be done in the next decade or two. A lot of these rules and norms are going to be set. I first got into privacy when, in the 90s, when IBM's chairman and CEO at that time thought, that the company needed to have both a point of view and a set of practices in the area that were really looking ahead at the trends. And I remember, kind of getting asked to go figure that out. And I remember kind of thinking about it for a second and realizing this is really an interesting space. I kind of have the yin and the yang going personally. I think a lot of us do. Privacy is a very personal thing. And I thought about it. I thought, I was looking at my mother and my father, and they were kind of the yin and the yang, right? My father, they both were immigrants from Europe. And my father had lived in a country in a regime that was kind of communist and not authoritarian, and he had a deep suspicion of authority. My mother, on the other hand, was and is a social butterfly. So if she actually used the internet and spoke English, she would actually be an avid Facebooker, and she's a social butterfly. And I think I have a little bit of both of them, in that this area is very evocative of conflicting emotions. And I think a lot of you, all of you who've been in this session the last 2 weeks, probably learned a lot about privacy law from the perspective of the individual. And it really is. I mean, global studies have been done. I know IBM commissioned one a number of years ago that looked at consumer attitudes in multiple countries and the variance among cultural, kind of groups of people from Germany to the United States to Russia to India to China is immense. So that's one first point, is that, as you think about the law and practice in this area, in a very globally interconnected world, one of the things that's not common is the fact that each of us has a different profile and a feeling about individual privacy and how much of us we're willing to put out, but also culturally, there are significant differences. And if you're doing business or representing an entity that is engaging in trade or commerce and is attempting to address markets, you ought to know that in India, it's very common for somebody to come right up to you and say, how much do you make? And how old are you? And are you married? Very common. I've had those questions asked of me. But in Germany, when I asked a colleague of mine who was on my team, could you please share your cell phone number so that we have an emergency contact list, so that if there's an issue, an incident, we are able to reach you? The answer was, no, I don't think you need to have that. And this is for work. And I never did quite get her number. And another example, in we had about 8 or 9 years ago, IBM is a huge company. And it's, you get tired calling the 1-800 number and say, I need to find Harriet Pearson. I would like to get transferred to her. Or would you have her email address? And our practice had been to give the name and the number out and the email address. Somebody said, well, why don't we save some money and make it easier to find one of the 450,000 people working at IBM, and we'll just do a direct, we'll do a search, and you can actually come in and look it up. And we said, somebody came to me and said, well, what do you think? I said, well, it's, we ought to be an opt-out. You ought to have people be able to opt out from being listed or able to be found for obvious reasons. But at the end of the day, it should be an expectation that you are accessible to the clients. And so be careful about putting a lot of information out, but the email address is company property, it's issued. And then the city. So we implemented this globally. There were a couple of countries, Japan being the most prominent, that said, no way, absolutely not. And it wasn't because they had a privacy law, it was cultural, deeply felt culturally that this was not to be done. And we didn't do it. South Korea is actually the same way. Sort of interesting, cultural. So the pivot I want to make is that when you're talking about individual or consumer privacy, when you pivot on it and say, okay, we're gonna generally have laws that speak to that. We're gonna generally have norms and practices that speak to what consumers or individuals want to see and hear and how they want to interact. But when you try to operationalize it, make it real, if you're a company selling to somebody or if you're government governing a set of individuals, you're going to have some common practices, concerns, call them what you will, and they cut across. And so the tagline for my little talk here is, privacy is very personal, but the governance of privacy, the governance of these issues in companies and organizations is actually universal. It cuts across. And almost all of us are lawyers or going to be lawyers. A couple of us have had operational responsibility for these issues in a company. I would submit that all of us here and anybody else who's interested in this topic needs to understand how it actually happens and works when you implement, because then you can give better advice and counsel and anticipate the risks better, right? So what I want to do is say, all right, now I've been responsible for information policy and practices at a somewhat large company for a number of years. And I just want to share with you a couple of the challenges or issues that we've grappled with. And I think one of the good things about being at a tech company that happens to be business to business is that we have been involved in servicing and looking at all the industries, like health, financial, government institutions, retail, you name it. I've seen a lot of the issues that pop up. So we're kind of like a clearinghouse, if you will. So what are the couple of the issues? Well, one is cross-border. Actually, no, let me start with this one. Principles versus detailed rules. So everyone here know what HIPAA is? It's somewhat detailed, right? The regulations around healthcare information are somewhat detailed. And if you're a health organization in the United States, you kind of have a sense of what you need to do. Fine. And it's important because that's important, sensitive information, that there be some structure. But if you look at the universe of personal information, it's said that in the last 2 years, there's been more data generated by humans and by sensors and intake, digital mechanisms than there's been data generated over the course of the entire history of humankind, right? Think about the magnitude of that and managing that. And organizations actually manage and are responsible for 80% of the data that's being generated. So that's why big data and how organizations approach big data is important. And you think about, well, how do you direct an organization to manage information in accordance with the laws or the policies or the commitments made to apply to the information? And I would submit to you that one of the ways we've instituted a program is to use principles rather than rules. So you govern a large global entity by saying, look, here is what we believe about information. Here's what we think we know we must do with information. And if you look at the policies and the principles that IBM has for its internal use of information, they are very similar to and aligned with what are known as Fair Information Practice Principles, or the FIPS. For those of you that have been studying this area, you know that FIPS are the underbelly or the foundation for all the laws across the world. And so the point one would be that 90% or more of the operations of how our program would run, and I know it's similar in other companies, is actually accomplished by hewing to or complying with those fair information practice principles. And then the rest is customized, according to culture, according to specific statutory or regulatory obligations. But you get a lot of the way there by doing that common baseline. So that's one point. Second point is around cross-border. So, the stats and the trend lines around the globalization of different kinds of business processes that cut across, HR information or technical support information or back office stuff, that the trend line has been there for quite a while. There's a lot of cross-border activity happening in the business-to-business context, and as people, I think we all realize that our own individual actions on the web are inherently kind of like global, right? So you have this data that's not necessarily, it's not flowing. There are not like pipes that are just like, whoosh, the data's going. It's kind of omnipresent and accessible. And some of the European laws, for example, trigger when you say, well, theoretically, you could access information that might be sitting on a server in the US. Oh, European law applies. So you have this challenge around managing information and complying with and figuring out how to have accountability in these settings that are very international. And that goes back to principle number one, or observation number one, which is why principles are so important, is there has to be interoperability. It's okay if Germany has a different standard than the United States. That's okay. But when you have the data potentially accessible and traveling across the way, you got to have regimes that are somewhat compatible for that transfer to happen, so that you don't wall off one area versus the other. So that's a second one. Another one is that these principles that I talked about, the fair information practice principles, it turns out that they're not quite complete. Turns out that, in particular, some of the leading thinkers in this area, such as Professor Nissenbaum, who wrote a wonderful book. I don't know did you talk about Nissenbaum's book, The Privacy in Context? I recommend that book. I think it's one of the groundbreaking books of the last few years. Talked about the importance of context as an addition to the fair information practice principle. So it's where you gather information from a person, the context in which you gathered the information really matters. So if I'm collecting information on a social networking site, if it ends up being used for judging an applicant's quality or fitness for a job, maybe I didn't expect that when I put the information out. I'll use an example that I was personally involved in when IBM and National Geographic asked for the IBM workforce voluntarily to supply a DNA sample for a research project called the National Genographic Project back in 2004, I think we did, so that National Geographic could go map out IBMers would contribute to a massive database that would map the progress of the human race, humankind. People said, well, what are you going to do with that information? And we realized context matters. We are never going to use it for anything else. And that led us to actually adopt a formal corporate policy that talked about we will never use genetic information if ever we touch it, or if you just choose to disclose it, we'll never use it for anything like work, determining your eligibility for health insurance. We were the first company to do that. It was sprung right off of this need for context. The US Department of Commerce, the Obama administration, actually recently adopted a new framework for privacy, consumer privacy. And one of the new, I think, intellectual add-ons in that report, in that framework, was the addition of this principle of context being important, as an addition to the traditional fair information practice principles. I think that's really groundbreaking. The challenge operationally, however, is to say, well, how do you predict and how do you deal with, as a company, as an organization, context? You don't really lawyer context really well. Oh, it depends on the context. Oh, yes. How do you write a memo on that? What's the standard of care? Where's the judicial opinion on that? There's not a lot out there. So that's where I think there's going to be a lot of evolution of what the standard is and the norm is. So that's another challenge, I think, operationally. Next observation would be the need for speed. There's a need for speed in this arena. Why? Well, because the internet kind of happens fast. You get on the internet, things flow and happen, and the pace at which we're living and working generally has quickened. I mean, we all carry around something that you get an email or a message or a text, and people expect an answer quickly. And the same things happen in the business context, and it's competitive out there. So there's a need for speed that runs right into the need for being deliberate about what you do with information, knowing what you're doing, knowing that you're complying. And it conflicts and comes into tension with some types of regulatory frameworks that, at least as they're stated on the black letter law, say, well, you should have a filing, you should have advance approval before you ship or transfer, allow a transfer of data. And that tension that builds up, and it happens in Europe, it might happen, it does happen in other parts of the world, is a tension that operationally is a challenge that cuts across enterprises, whether you're healthcare, retail, an ad-supported marketing or advertising-supported organization. That is an issue, because if there's a need for speed and the business is chomping at the bit to do something, and you're saying, wait, let's go analyze the law, let's go ask 35 different jurisdictions, and then we'll do the analysis, and then we'll tell you what to do, that can take, as some of you probably know, that can take a long time. And so there's an opportunity there for automation, process improvement, streamlining, and again, it goes back to, are you kind of trying to do a rule book approach, or are you trying to do principles and hew to what the policies are meant to do, as opposed to trying to check off the boxes? So need to speed is, I think, an important aspect of, and that's common across, and in multiple industries. Security. There's a need to secure the data, and security is an enabler. And even more so than privacy, the need for security and how one secures data cuts across. It's a very global discipline. And you don't get much argument about the need for setting proper IT security policies, workforce education, the kind of enabling technologies. That is absolutely common. And as those of you who studied the US data breach notification laws know, it is actually quite an important enabler, because otherwise you're going to end up in court or negotiating consent decrees because your client has been unable to protect the data that was entrusted to them, and thus has to explain what they didn't do. So that's, again, a key issue that cuts across. All of these areas, I think, sound as if they're challenges, and they are. And I think that organizations are increasingly appointing people who are privacy officers to help them with these challenges. And that's one reason the IAPP, which is sponsoring this effort and is based here in the Maine, New Hampshire area, has grown from, I think, how many were we, Trevor, when you came on board? 50, 100, 500? 300 members. And I was there when it was 25 members. And we said, there are a few of us here who are doing this, and we need a place to go compare notes. And so then we grew to about 300, and we thought, oh, this is great. It's a great rate of growth. And maybe we needed somebody who's like professional, who could run this for us, part-time maybe, never more than half-time. And we found Trevor, who was interested. And then Trevor came on, and the profession kept growing, and Trevor has spearheaded growth of the association to match for over 10,000 people. The people who are considered to be privacy pros in organizations partner with lawyers, a lot of lawyers in the field of privacy, and lawyers who are advising those. They partner with their IT teams, particularly the security teams in the IT world. They partner with HR. They partner with marketing, everybody. That challenge of how do you do this is a great opportunity for those of us who are able to participate and help the organizations that we work with realize the value of the data and minimize the risk, enterprise risk. That's an opportunity. The other opportunity, I would argue, is around innovation and entrepreneurship. So some of these issues that I've just talked about, if you kind of think through the practical implications of them, it's, how big can that spreadsheet get? How many columns and rows can you get if you're trying to map your data and figure out where the heck it is? It blows the mind. You can't do it. And so that's kind of where the standard of care, or kind of the reasonable duty is right now. It's like still, most organizations, where's the data? Well, I got it in this database, that database, and I've got the spreadsheet here. And that's kind of like where folks are. The reality, though, is that the leading edge, the leaders, have developed and are developing automated ways of spotting where the data is, classifying it on the fly, detecting where there might be leaks. That's where the standard of care is evolving to, and that's an opportunity for those who can get in the space, not just technologists, but other kinds of organizations, to actually innovate your way out of some of the gating issues or the limiting issues right now that are preventing things from happening, like, well, how can an individual actually know or consent? How can we determine whether data really was erased or gotten rid of in an authoritative way? How do we ever know that data is really truly anonymized? Right? There's a raging debate right now in the policy circles about is anonymization ever good enough? And can you re-identify it? And there's a lot of opportunity there for innovation. And I've seen some of that work inside IBM's research labs, and it's really groundbreaking. There was one innovation that we announced a couple of years ago called homomorphic encryption. And it was one of these where, one very, very smart mathematician conquered a problem that had been confounding folks since the 70s around how do you encrypt data in a very, very secure way, but at the same time are able to reach inside and manipulate the data and get value out of it and insight without actually uncovering or seeing kind of what was in it. So think of like a box, and you put your hand in, and you manipulate it, you get value out of it, but no one ever saw the names, you didn't see the phone numbers. Now that's kind of a marketer's dream. Then you don't have to worry about, oh, it's personal information. Well, it's not. There's PI inside, but I never touched it. And that theoretical breakthrough, the kind of encryption necessary to do that, was an advance that was very well recognized in the technical fields and was immediately snatched up as something to really try to make practical. It's not practical yet. They're on the road to making it that way. It'll take a few years. But when that innovation emerges into the marketplace, a lot of the legal concepts that we've been talking about will change. The law will adjust to recognize that. And that's one of the powerful opportunities for the kind of innovation I'm talking about, at the deep technical level as well as at the process, and actually at the entrepreneurial level of even the IAPP and the University of Maine, recognizing these trends, jumping on them, and being part of them going forward. So that's a little bit of a tour through some issues. Am I okay on time? So I look forward to answering or talking with you at the Q&A time of this session and through the day. But I really am delighted to be here, to be part of the innovations happening at the University of Maine, and to be here, especially in this in-between stage as I transition from one wonderful organization to another. So thank you very much.